The probate courtroom smelled like floor wax and recycled air, and something underneath both of those things that I can only describe as the specific staleness of a room where people come to argue about the dead. My stepmother was already seated when I walked through the door. She turned to look at me the way you look at something you have already decided is not a threat. Her attorney leaned toward her and said something low. She nodded. I sat down, opened my folder, and did not look at her again. But to understand what happened in that room, you need to know who I was before I walked into it. My name is Dana Reeves. I was 36 years old when my father died, and I had been a paramedic with Shelby County Emergency Medical Services in Memphis, Tennessee, for 9 years. My unit ran 12-hour shifts out of Station 7 on Lamar Avenue, and in 9 years I had worked somewhere north of 400 cardiac arrests, 11 mass casualty incidents, and one tornado that came through a residential neighborhood on a Tuesday afternoon in April and left us working 6 scenes simultaneously with mutual aid from 2 counties. My supervisor at Station 7, a man named Curtis Briggs, who had been in emergency medicine for 28 years, told me once that I was the calmest person he had ever watched work a code. He did not mean it as a compliment exactly. He meant it as a precise observation. I took it as both. The thing about working that job for 9 years is that you develop a specific relationship with your own nervous system. You learn to read the difference between a situation that requires speed and a situation that requires stillness. You learn what real instability looks like from the inside of a person, and you learn what performed instability looks like, because you see both regularly, and they are not the same thing at all. I knew the difference before I ever set foot in that courtroom. I had known it for a long time. My father's name was Thomas Reeves. He worked 30 years as a high school history teacher at Whitehaven High School in Memphis, and he retired in 2013 with a pension, a house in Germantown he had paid off 7 years early, and the particular contentment of a man who had done exactly what he intended to do with his life, and was not troubled by any alternative version of it. He was methodical and specific, and he kept a yellow legal pad on his kitchen table where he wrote down everything he needed to remember, grocery lists and appointment times, and things he had read that he wanted to think about more carefully. That legal pad. A fresh one every few months, the same brand every time. From the same office supply store on Poplar Avenue. I can see his handwriting on it if I close my eyes. I still have the last one. It is in the drawer of my nightstand, but I'm getting ahead of myself. He met Carol when I was 27. I was 4 years into EMS by then, and I was working nights, and I was the kind of tired that accumulates across years rather than shifts. He called me on a Sunday in March and said he had met someone at the church social committee and that he wanted me to have dinner with her. I drove to Germantown, and she made baked chicken, and she asked me about my work with what seemed like real interest, and she had a laugh that was warm and unguarded, and I thought, good. He has been alone for 11 years since my mother died. He is allowed to have this. Carol had a son from her first marriage. His name was Derek. He was 24 the first time I met him, living with a roommate in Midtown, working at a title company. He was pleasant and forgettable in the way that some people are pleasant and forgettable, and I filed him in the category of people who are simply part of a situation, rather than people who are doing anything in particular. I was wrong about that. I would understand later exactly how wrong I was. My father married Carol in 2016. I was in the wedding. I stood in the second row and watched him say the vows, and I told myself that the small unease I felt was mine to manage, not his to answer for. For 18 months, everything appeared fine in the way that things can appear fine when you are only seeing them on holidays and the occasional Sunday dinner. Carol remembered my birthday. My father and I talked on the phone every week. The calls were the same length they had always been, which was never very long because he was a man who used the phone to confirm information rather than to have conversations. And the information was always the same. I am here, things are fine, I love you. The first thing I dismissed was that he mentioned, offhand in the spring of 2017, that he and Carol had updated their estate documents. He said Carol had recommended an attorney she knew. I noted it and let it go. The second thing I dismissed was that Derek started appearing at family dinners more regularly. Not every week, but often enough that his presence stopped feeling occasional. He called my father underscore underscore, quote underscore zero, underscore underscore, within 6 months of the wedding. I told myself that was just how some people were with step-parents. The third thing I dismissed was a phone call from my father in the fall of 2018, in which he seemed to lose the thread of what he was saying twice in the same conversation. He had never done that before. He apologized and said he was tired. I told myself he was 68 years old and tired was allowed. I found out later that while I was driving home from that call, Carol was on the phone with Derek, and the conversation they had that night was the one that set everything else in motion. He was diagnosed with early vascular dementia in January of 2019. The diagnosis came from a neurologist at Methodist Hospital named Dr. Patricia Wynn, who documented in her initial assessment that his short-term memory and executive function were measurably impaired and that he was likely in the moderate early stage. She noted that he retained significant long-term memory and social function, which meant that in a casual conversation he could appear essentially normal. The disease was specific in what it had taken and what it had left behind, and what it had left behind was enough of him that people who did not know what to look for would not see it. Carol knew what to look for. She had watched it for months before the diagnosis, and she had been making plans. I did not know about the diagnosis when it happened. Carol told me in March, 2 months after the fact, in a phone call that lasted 9 minutes, and that she ended by saying she had things under control and that she would keep me updated. I drove to Germantown that weekend and sat with my father, and I watched him carefully the way I watch patients, looking for what the body is doing underneath what the person is saying, and what I saw made something go quiet inside my chest, in the specific way that something goes quiet when you are working a scene and you have just understood that the situation is more serious than you were initially told. He was still him. That was the hardest part. He was still entirely himself in every way that mattered most. And the disease was working on him in the spaces between those things, in the executive function and the short-term memory and the capacity to track a complex document. And those were exactly the spaces that matter most when someone puts a piece of paper in front of you and asks you to sign it. He died on a Wednesday morning in June of 2021. Carol called me at 7 in the morning. I drove to Germantown and I sat with him, and then I drove home and I did not sleep that night. The estate attorney called me 11 days later. His name was Richard Cho, and he had been handling my father's legal documents for 6 years. He asked me to come in. His voice on the phone was careful in the way that voices get careful when the person speaking has been thinking about how to say something for a while. I sat across from him in his office in East Memphis on a Thursday afternoon, and he told me that my father had executed a new will in September of 2019, 8 months after the dementia diagnosis. Under the new will, the house, the pension beneficiary designation, and the entirety of the liquid savings transferred to Carol outright, with Derek listed as secondary heir. My name appeared nowhere in the document. Then Richard Cho slid a second piece of paper across the desk. He said my father had left a letter for me, sealed, to be given to me directly. He said my father had asked him to hold it separately from the estate documents. I took the envelope. I sat in my car in the parking lot for 6 minutes before I opened it. My father's handwriting on the pages inside was uneven in a way I had not seen before. Some letters running together, some lines wandering slightly from the horizontal. He had written 4 paragraphs. I am not going to tell you everything those paragraphs said. I will tell you that by the time I finished the 4th one, I understood that he had known something was wrong, that he had known it and had not known how to reach me across it, and that what he had managed to do was write it down and ask Richard Cho to make sure I received it. Something settled behind my sternum in that parking lot, cold and very specific. Not grief, not yet. Something more like clarity. I called Richard Cho from the car and told him I was going to contest the will on the grounds of undue influence and lack of testamentary capacity. He said, quote, 1. They had no idea what they had just done, and I was going to let them keep not knowing, for a while. Now, at this point, I want to be honest about where my head was. I had the letter. I had 9 years of training in reading situations clearly and in not letting what I was feeling show on my face before I understood what I was dealing with. I did not have a plan yet beyond those two things. But Richard Cho had said something in that phone call that I kept returning to. He had said, quote, 2. He had held that letter for 2 years. He had watched those estate documents get executed. He had called me in person instead of sending a form letter with a check. There was something he had not told me yet, and I needed to find out what it was. Because what I was about to learn in the next few weeks was going to change the shape of everything I thought I understood about the last 2 years of my father's life. Richard Cho had been practicing estate law in Memphis for 23 years. He was 63 years old and he spoke with the economy of a man who had learned that extra words in legal matters create extra problems. He wore reading glasses on a cord around his neck, and he kept his office in a deliberate, functional order that I recognized as the workspace of someone who finds thinking easier when the physical environment does not compete with it. I liked him the moment I met him, which for me means I decided he was not going to waste my time. I went back to his office 4 days after the letter. I told him I wanted to know everything he had observed and everything he knew, and I wanted it in the order it happened rather than in the order he thought I needed to hear it. He was quiet for a moment. Then he said this. He said that in August of 2019, 1 month before the new will was executed, my father had called him from a number Richard did not recognize. My father had told him he was calling from a neighbor's phone because he did not want to use his own. He had said he was confused about some documents Carol had shown him and he wanted to talk. Richard had arranged a meeting for the following week. My father had come alone, which Richard said was the first time in over a year that he had appeared at the office without Carol present. His hands had been unsteady and his speech slower than before, but he had been clear and deliberate and he had said 2 things. The first was that he could not fully recall what he had signed in recent months. The second was that he wanted to write a letter to me and he wanted Richard to hold it until he was gone. Richard had documented the visit in a file note the same afternoon. He slid it across the desk to me now. I read the date on the file note, August 14th, 2019, 6 weeks before the new will was signed. My father had called his attorney from a neighbor's phone because he did not feel safe making that call from inside his own house, and 6 weeks later, he had signed a document that removed me from his estate entirely. I asked Richard why he had not intervened at the time of the signing. He said, "Because your father asked me not to. He said he did not want conflict while he was still alive. He said he was tired of managing it." He looked at me directly. I honored his request. I have not been certain that was the right decision. That was everything he said on that point. It was sufficient. I retained an attorney named Sonia Garrett the following week. She had been recommended by a colleague at Station 7 whose family had gone through a contested estate 2 years earlier in Shelby County. Sonia had practiced estate litigation for 21 years, and she had the manner of someone who had seen enough of what families do to each other under financial pressure that the details of any particular case no longer surprised her, though she remained interested in them. She was direct on the phone, and she asked precise questions, and at the end of the initial call she said, "Bring me the letter, the file note, the will, and the neurologist's records from the diagnosis period. We need Dr. Wynn's documentation of his cognitive status in the months surrounding the September signing." I obtained the medical records through a formal request to Dr. Wynn's office. The records contained a clinical note from July of 2019, 2 months before the will was executed, in which Dr. Wynne documented that my father's executive function and capacity for complex document comprehension had declined measurably since the initial assessment. The note included this sentence: she recommended against presenting him with significant legal or financial instruments during periods of elevated symptom activity, and she noted that his condition was likely to fluctuate, and that his presentation on any given day might appear more intact than his actual functional capacity. He had signed a new will 8 weeks after that note was written. Carol had driven him to the appointment and had been present in the waiting room. Sonia read the clinical note and said, "This is the foundation. But I want to know about the pension beneficiary change separately, because that instrument sits outside the probate estate, and we need to know when it was altered and under what circumstances." I had not separated the pension from the will in my thinking. I did that now. I submitted a formal records request to the Shelby County Schools retirement system. The response came back in 9 days. The original beneficiary designation on my father's pension, filed in 2004, listed me as the sole beneficiary. A change of beneficiary form had been submitted in June of 2019, 3 months before the new will, and 2 years before he died. The new designation listed Carol as primary and Derek as secondary. The form carried my father's signature. The signature was shakier than anything I had seen from him in documents before the diagnosis. And then I looked at the submission record, and I saw the date, and I had to sit down. The pension change had been submitted 6 weeks after Dr. Wynn's first assessment. 6 weeks after a neurologist had formally documented that my father's executive function was impaired. Someone had put a change of beneficiary form in front of him and obtained his signature 6 weeks after that finding, and then submitted it to the retirement system while the ink was still fresh. Sonia looked at the submission date and the assessment date side by side and went very quiet. I watched her read both documents twice, then she set them down and said, "This is not a family disagreement about a will. This is a pattern, and patterns have records." The unexpected piece came from a woman named Helen Marsh. She was Carol's younger sister, 61 years old, and she had been present in the Germantown house for an extended visit during the summer and fall of 2019. The precise window in which the pension change and the will had both been executed. She called Sonia's office on a Thursday morning in late October, having found the contact information through the Shelby County Probate Court filings, which are public record. Sonia called me the same afternoon. Helen told us that she had watched what happened in that house during those months and that she had told herself it was a family matter and that she had not wanted to interfere, and that she had not been able to stop thinking about it since my father died, and that she had decided she was not going to carry it any further. She described specific things. She described watching Carol present my father with documents at the kitchen table on 3 separate occasions during her visit, always in the evening when he was tired, always without asking whether he wanted to review them with anyone else first. She described my father asking on one of those occasions what exactly he was signing, and Carol telling him it was routine paperwork they had already discussed, and my father nodding and signing because he trusted her, and because the disease had taken enough of his short-term memory that he could not verify whether they had in fact discussed it or not. She described Derek being present in the house during 2 of those 3 occasions, sitting in the adjacent room, visible through the doorway. She said she had told herself Carol loved him. She said she still believed that was true. She said loving someone and doing what Carol had done were not mutually exclusive, and that she had taken longer than she should have to understand that. Helen gave a sworn affidavit. She was specific and she was steady, and she said she would appear in court if asked. I thanked her, and she said she did not want to be thanked. She wanted to do what she should have done sooner. After I ended the call, I sat at my kitchen table for a while. The lamp on the counter was on, and the window was dark, and I could hear traffic outside, and nothing else. The cold, specific thing behind my sternum had been there for 4 months, and I had stopped trying to make it leave. Carol's attorney sent a letter to Sonia in early November. The letter offered a settlement of $35,000 and several items of personal property from the house, including furniture that had originally belonged to my grandmother, in exchange for a full release of all claims against the estate. Sonia called and read it to me. I said no. She said, underscore, underscore, quote, underscore, 8, underscore, underscore. I want to pause here for a moment. Because by November I had everything. I had Richard Cho's file note from the neighbor's phone call. I had Dr. Wynn's clinical assessment from July of 2019. I had the pension change submission dated 6 weeks after that assessment. I had Helen's affidavit describing exactly what the kitchen table looked like on 3 specific evenings during the summer. My father's estate was being restructured around him. I had my father's letter in his own unsteady handwriting. I had built something that could not be argued with from any direction. And I had not told Carol or Derek or their attorney what any of it looked like from where I was standing. Sonia looked at everything arranged across her conference table one afternoon and said, underscore, underscore, quote, underscore, 9, underscore, underscore. I understood exactly what she meant. I had been in rooms before where the person on the other side of the situation had more confidence than information, and I knew what that confidence looked like in the 60 seconds before it had nowhere left to go. But here is what none of them knew. Helen's affidavit was on our exhibit list, described in standard procedural language as a witness statement from a third party with direct observational knowledge of the testator's condition during the relevant period. Carol's attorney had reviewed the exhibit list. He had seen Helen's name on it. He had apparently not asked Carol directly whether her own sister had been in the house that summer, or if he had asked, Carol had not told him what Helen had seen. The affidavit's contents were not known to the other side until the moment Sonia entered it into the record. I need you to understand what Helen's statement actually meant in the context of everything else. The pension change alone was a document with a questionable signature on a suspicious date. The will alone was a document that could be argued as a considered decision by an elderly man with some cognitive decline. But Helen had been in the room. Helen had watched it happen on 3 specific evenings, and she had written down what she saw, and she was prepared to say it in open court, and there was no version of Carol's argument that survived that testimony intact. She had done this carefully and deliberately over a period of months, and she had done it in front of a witness she had trusted not to act, and that trust had been the single miscalculation in an otherwise methodical operation. It was not the first time I had watched a carefully constructed situation come apart because of one person who decided they could not stay quiet anymore. In 9 years of emergency medicine, I had seen it in families, in bystanders, in people who had been present at something and had tried to live with it afterward. The ones who came forward always said the same thing. They said they had not been able to stop thinking about it. Helen had not been able to stop thinking about it for 2 years, and that was the piece Carol had not accounted for. Everything I had built over 5 months had been preparation for 1 room, 1 table, 1 morning. There was one sentence I had been holding, and I knew exactly when to say it, and I knew what it would do to the room when I did. Sonia and I parked in the courthouse garage on a Tuesday morning in December at 9:12 in the morning. I checked the time on my phone before I got out of the car. The air was cold and smelled like exhaust and concrete, and I stood still for a moment before I followed Sonia toward the elevator, the way I stand still for a moment at the beginning of a shift before I put on my badge and walk through the door. The probate courtroom on the 3rd floor of the Shelby County Courthouse had ceiling tiles that had been replaced in sections over the years so that some were bright white and some were the color of old cream, and the effect was of a room that had been maintained without ever being quite finished. The fluorescent lights buzzed at a frequency you stopped hearing after about 10 minutes. There were 3 windows on the south wall, and through them the December sky was flat and gray and entirely without feature. I was wearing a dark blazer over a white shirt and dark trousers. I had pressed everything myself the night before in my apartment, and I had done it carefully, because the choice of what to wear to a hearing, where a woman intended to call me emotionally unstable in front of a judge, was not a casual one. I wanted to look like someone who makes decisions precisely and carries them out without drama. I wanted the clothes to say that before I said anything myself. Carol was already at the opposing table when Sonia and I came through the door. Derek was beside her in a jacket that looked recently purchased. Carol turned to look at me when I entered and then turned back to the front of the room in a single unhurried motion, the motion of someone who has decided the outcome in advance and is simply waiting for the process to confirm it. Derek looked at his hands. Their attorney was a man named Garrett Holloway. He arranged his files on the table with the deliberateness of someone performing competence for a room, and he and Sonia exchanged the brief professional acknowledgement of opposing counsel who have worked the same courts long enough to find each other unremarkable. The judge was the Honorable Margaret Solis, who had been on the Shelby County probate bench for 16 years. She was 64 years old, with reading glasses she wore on a cord, and the specific patience of someone who has presided over enough family disputes to know that most of the noise in a courtroom is inversely proportional to the strength of the underlying case. Garrett Holloway opened. He was prepared, and he was smooth, and he built his argument in the way arguments get built when the person making them believes the other side has only grief to work with. He described my father as a man who had made a clear and deliberate choice to provide for the woman he had spent his final years with. He described me as a daughter who had been largely absent during the period of her father's illness, who had not been present for the daily work of his care, who had not carried the weight of it. He used the phrase, quote, 10, and he said it twice. He said the contest was the predictable response of someone who had not accepted that her father had, freely and of his own judgment, built a new life. He did not use the word, quote, 11 in his opening statement. Carol did that herself, later on the stand, when Garrett asked her why my father had not discussed the estate changes with me directly. She said, in a tone of careful reluctance, that my father had expressed concern about my emotional state for some time. She said he had described me as someone who did not handle change well. She said he had used the word underscore underscore, quote, underscore 1, 2, underscore underscore underscore, to describe how he imagined I would react. She delivered all of this with the expression of a woman who regrets having to say something, and is saying it anyway because she has been asked a direct question. I sat with both hands flat on the table in front of me, and I did not move, and I did not change my expression, because I had spent 9 years learning to keep my face still when the situation required it, and this situation required it. Garrett rested. Sonia stood. She moved through the evidence the way I move through an assessment, starting with what could be established beyond argument and building from there. She entered Dr. Wynn's clinical note from July of 2019 into the record and read the relevant sentence aloud once without emphasis, without pause. She entered the pension change submission record and stated the date of the neurological assessment and let both dates sit in the room without explaining the relationship between them because the relationship was self-evident to anyone who was listening. Then she entered Helen's affidavit. She read it in full. She read the part about the kitchen table and the evenings and the documents, and my father asking what he was signing, and Carol telling him it was routine paperwork they had already discussed. She read the part about Derek visible through the doorway on 2 of those 3 occasions. She read it plainly, at a steady pace, and she set it on the evidence table and sat down. Garrett Holloway looked at the affidavit. He looked at Carol. Carol was looking at the table in front of her with an expression I recognized from the field. The expression of a person who has just understood that the situation is not what they were told it was going to be. Derek's jaw moved. He did not say anything. He looked at the window. Judge Solis picked up Helen's affidavit and read it. She read it fully, without hurrying, and the room was quiet while she did. When she finished, she set it down and looked at Carol over the top of her reading glasses for a long moment. Then she made a note on her pad and looked at Sonia. Sonia called Richard Cho. He described the August phone call and the neighbor's phone and my father's statement that he was uncertain what he had signed in recent months. He described the file note he had written the same afternoon. He was precise, and he added nothing that was not in the note. Garrett's cross-examination produced nothing because the note existed and the date on it existed, and neither of those things could be argued into a different shape. Sonia called Helen Marsh. Helen described the kitchen table on 3 specific evenings in the summer of 2019. She described my father's face when he asked what he was signing. She did not look at Carol while she testified. She looked at the judge, and she spoke at a measured pace, and her voice did not waver. She was 61 years old, and she had carried this for 2 years, and she was done carrying it. When Helen stepped down, the room had a particular quality of stillness, the stillness of a space where the available arguments have been exhausted. Sonia nodded at me. I took my father's letter from the folder and placed it in the center of the table and did not say anything. Sonia entered it into evidence and the clerk carried it to Judge Solis. The judge read it. She read all 4 paragraphs without hurrying, and nobody in the room spoke while she did. Garrett Holloway looked at his notepad. Carol looked at her hands. Judge Solis set the letter down. She looked at Carol, not at Garrett, not at me, directly at Carol, and she held that for a moment. I said the sentence I had been holding for 5 months. I said it quietly, to no particular point in the room, in the same tone I use when I am recording observations on a patient chart. I said, he called his attorney from a neighbor's phone because he did not feel safe making that call from inside his own house. Nothing in the room moved after that sentence. That was correct. It did not need to move. It sat in the air, and every person in the room made their own private decision about what to do with it, and those decisions showed on their faces in small ways, in the set of Garrett Holloway's mouth, and in the way Derek turned toward the window, and in the way Carol's hands on the table became very still. Judge Solis spoke for 6 minutes. She said the evidence established a credible and documented pattern of undue influence exercised during a period of formally assessed cognitive impairment. She said the pension beneficiary change, executed 6 weeks after Dr. Wynn's initial assessment, combined with the will execution 8 weeks after Dr. Wynn's follow-up note, combined with the direct observational testimony of a witness present in the household during the relevant period, constituted sufficient grounds to find that the testator had not acted from free and independent judgment. She said the will contest was sustained. She said the pension beneficiary designation would be referred for separate administrative reversal. She did not look at me while she said any of it. She was looking at the record in front of her. She did not need to look at me. The room was very quiet. Outside, through the south windows, the flat gray December sky sat over the city without moving. Someone's phone vibrated on the opposing table, and nobody reached for it. I walked out of the courthouse and took the stairs to the parking garage and stood next to Sonia's car for about 2 minutes. I put one hand on the roof and looked at the ceiling of the garage and breathed. That was all. Sonia came out 4 minutes later and unlocked the car, and we got in, and she started the engine and she said, "The pension reversal will take 60 to 90 days through the retirement system." Then, to the windshield rather than to me, she said, "Your father kept good records. It helped." We pulled out of the garage and I watched Memphis go past the window, and I did not say anything for a long time. Carol did not appeal. The will was voided, and the estate distributed under the 2004 document, which named me as sole heir. The pension reverted 71 days after the hearing. Derek moved out of the Germantown house in February. I have not had any contact with him since. Carol called me once, in the spring. The call lasted 4 minutes. She did not apologize. She said she had loved my father genuinely, and she wanted me to know that she believed that was true. I told her I did not doubt it. She said she was sorry for how things had gone. I said I understood. That was the last time we spoke. 2 years have passed. I still work out of Station 7, though I moved to the day shift 8 months ago and the hours suit me better now. I wake up most mornings before 6, make coffee, sit at the kitchen table with the window cracked if the weather allows. I sold the Germantown house and kept very little from it. I kept the yellow legal pad from the kitchen table drawer, the last one, with his handwriting on it, grocery lists and appointment times, and 3 lines from a book he had been reading that he wanted to think about more carefully. It is in my nightstand drawer. I do not take it out often. I do not need to. What the last 2 years taught me was not what I expected to learn. I expected to learn something about greed or cruelty. Instead, I learned something about visibility, specifically about how a person can be completely present in a situation and completely unseen at the same time, how the people who are watching carefully are often the ones nobody thinks to account for, how the records that matter most are sometimes the ones kept by a neighbor's phone call or a file note written on a quiet August afternoon by an attorney who said nothing until the moment when saying something was the only right thing left to do. There is one more thing I have not told you yet, and it is in the next video, because this story has a second chapter that begins with what I found in the Germantown house when I went to collect my father's personal effects, inside a box in the hall closet that Carol had apparently not thought to go through. If you want to hear that part, it is coming. And if any piece of this reminded you of something in your own family, I would want to hear about it in the comments. Those conversations matter more than you might think.